Chapter 4 of Particular Bonds. The preceding observations are applicable to bonds in general. It is now proposed to consider such particular bonds as are most worthy of notice, and in pursuing this part of the subject the following arrangement will be observed. First, bonds which owe their origin to some statutory enactment. This class is of considerable extent, since where a security is required by statute, it is for the most part by bond. The statute in general prescribes the form of the condition, which must be strictly adhered to, but it has been held that bonds taken by commissioners under the Tax Act is not void if taken with one surety only. Notwithstanding the statute directs to, it would be unprofitable to enumerate every case of a bond required by statute. The present observations will therefore be confined to those particular bonds the law respecting which is more generally useful and important, viz. Bail bonds, replevin bonds, administration bonds, and bastardy bonds. 2d. Bonds to the validity of which some formality is required by statute, as annuity and arbitration bonds. 3d. Particular bonds, not controlled or regulated by any provision of the legislature, as bonds to replace stock, bottomry and respondentia, post-obit, and indemnity bonds. Section 1 of Bail Bonds, by the 23 Hen. 6, c. 10, s. 5, it is enacted, that sheriffs, under-sheriffs, bailiffs of franchise, and other bailiffs, shall let out of prison all manner of persons by them or any of them arrested, or being in their custody by force of any writ, bill, or warrant, in any action personal, or by cause of indictment of trespass, upon reasonable sureties of sufficient persons having sufficient within the counties where such persons be so let to bail or main prize, to keep their days in such place as the said writs, bills, or warrants shall require, such person or persons which be or shall be in their ward by condemnation, execution, capias ut legatum, or excommunication, surety of the peace, and all such persons which be or shall be committed to ward by special command of any justice, and vagabonds refusing to serve according to the form of the statute of labourers only excepted, and that no sheriff, or any of the officers or ministers aforesaid, shall take, or cause to be taken or make, any obligation for any cause aforesaid, or by colour of their office, but only to themselves, of any person, nor by any person that shall be in their ward by the course of the law, but by the name of their office, and upon condition written that the said prisoners shall appear at the day contained in the said writ, bill, or warrant, and in such places as the said writs, bills, or warrants shall require. And if any of the said sheriffs, or other officers or ministers aforesaid, take any obligation in other form by colour of their offices, it shall be void. The sheriff is not authorized by the above statute to admit to bail persons arrested by him under process issuing upon an indictment at the quarter sessions. But though it was formerly considered that the sheriff could not take a bail bond for an attachment on contempt for non-payment of costs, on the ground that such attachment was a criminal process, it has been by later authorities determined that a bond taken by him in such cases is good, since, as the non-payment of money creates a civil right, the attachment which is issued to enforce that right must be considered in the nature of civil process. It has also been formally held that the sheriff could not take bail on an attachment out of chancery, because the statute refers only to courts of common law. It appears, however, that though such bonds are not within the provisions of the statute, nor compellable to be taken, yet that they are good at common law, and that whether or no they shall be taken is entirely in the discretion of the sheriff, as regulated by the practice of the court. The security required by the statute is a bond, and therefore any agreement not under seal is void, and the bond must be made to the sheriff himself by his name of office, and not to his bailiff, for the statute applies only to those bailiffs who have the return of process, and when process is directed to the sheriff, the indemnity must be to him. There must be a condition to the bond, therefore, if the bond be single, on with an impossible condition, as to appear at a day past, or if it be executed before the condition is filled up, it will be void. And the condition should be for the defendant's appearance at the day and in such place as is by the writ required. Since the alteration of the process for the commencement of personal actions, the terms of the condition are necessarily altered, and many of the former decisions on this subject are no longer applicable. If the security be conformable to the statute in the above respects, a variance in the description of the action will be immaterial, for it is not necessary that the bond should disclose the nature of the suit, and if wrongly stated, it may be rejected as surplusage. Where the writ issued against two defendants, and the sheriff took a bail bond conditioned for the appearance of one only, it was held no ground of demurrer. Although the statute uses the word sureties in the plural number, the bond will not be void if taken with one surety only. It is, however, the duty of the sheriff to take more than one surety, and the number may be 3 or more if he think fit. If several sureties be tendered, and 2 of them are respectively worth property to the amount of the penalty of the bond, it is immaterial what the others are worth. The 12 Geo. 1, c. 29, s. 2, directs that the sheriff shall take bail for the sum endorsed upon the writ, and no more. In practice, however, it is always taken in double the sum sworn to, and if it be taken in a sum above that amount, the bond will not, for that reason, be void. The bond must be executed and taken on or before the 8th day limited by the process for putting in bail. If the defendant neglect to put in special bail within 8 days after the execution of the writ, inclusive of the day of execution, the bond is forfeited. At common law these bonds were not assignable so as to give the plaintiff a right to sue upon them in his own name. That power has been granted by the 4th Ann. c. 16, s. 20, which enacts that if any person shall be arrested by any writ, bill, or process, issuing out of any of the courts of record at Westminster, at the suit of any common person, and the sheriff, or other officer, taketh bail from such person against whom such writ, bill, or process, is taken out, the sheriff or other officer, at the request and cost of the plaintiff in such action or suit, or his lawful attorney, shall assign to the plaintiff in such action the bail bond, or other security taken from such bail, by endorsing the same, and attesting it under his hand and seal in the presence of 2 or more credible witnesses, and if the said bail bond or assignment or other security taken for bail be forfeited, the plaintiff in such action after such assignment may bring an action and suit thereupon in his own name, and the court where the action is brought may by rule of the same court give such relief to the plaintiff and defendant in the original action and to the bail, as is agreeable to justice, and such rule shall have the effect of a defeasance to the bond. It should be observed that though this statute uses the words action or suit, it is only applicable to bail bonds given upon process at common law, and therefore a bail bond given by a party attached for contempt in not putting in an answer in chancery is not assignable. The assignment may be made either by the sheriff himself, or by the under-sheriff in the name of the sheriff. It is doubtful whether it can be made by the sheriff's clerk, though it seems that the seal of office is sufficient to give it validity. Whoever may sign it. Where the assignee sues upon the bond, the action must be brought in that court in which the original suit has commenced, even though it be an inferior court, or the defendant be an attorney of another court. But if the sheriff himself put the bond in suit, the action may be brought in any court. The writ in the original action, the court out of which, and the name of the person against whom it issued, should be accurately stated in the declaration, but though usual, it is not necessary to aver that the writ issued upon an affidavit of debt, or that the sum sworn to was endorsed upon the writ, or that the defendant in the original action was arrested, for the court will presume that the arrest and all the proceedings previous to the bail bond were regular. The bond, and particularly the date of it, if not laid under a videlicet, must be correctly stated, for if the bond appear to have been taken after the 8 days limited for putting in special bail, the declaration will be bad on demurrer. It is, however, sufficient to declare on the bond according to its legal effect, without stating the very words of the condition. It may be alleged that the sheriff assigned the bond to the plaintiff without adding that the assignment was made under the hand and seal of the sheriff, and although the statute requires the endorsement to be made in the presence of 2 witnesses, it is not necessary to set forth the names of the witnesses in the declaration, and if it be alleged that assignment was made in the presence of 2 credible witnesses, it is sufficient, without averring that the endorsement was attested by 2 credible witnesses, But if the assignment appears on the declaration to have been attested by one witness only, it will be demurrable. As the assignment is not by deed, a proffer is unnecessary. Formerly any matter of fact which rendered the bond void, as that it was executed after the time limited by the process for putting in special bail, or before the condition was filled up, might have been taken advantage of under the plea of non est factum, but now that plea only puts in issue the fact of the execution of the bond, and all matters which show it either voidable or void must be pleaded specially. The defendant may plead that no process issued against the principal, or that the debt was levied on the principal since the commencement of the action, or having craved oyer of the condition he may plead an appearance at the day therein mentioned, and this plea should conclude with a verification by the record. It may also be pleaded that the bond was not assigned according to the form of the statute, or that it was taken for ease and favour after the time limited for putting in special bail, and to this plea, if the action be at the suit of the sheriff, he should pray an enrolment of the bond, and after setting it out, state that he was sheriff, the defendant's arrest, that the bond was made to him as sheriff, and traverse the ease and favour. If the action be at the suit of the assignee, the replication should state that the bond was duly executed, and, denying the ease and favour, conclude to the contrary. But the mere practice of the court, without it goes to the merits of the defence, cannot be pleaded, nor can matters of defence in equity or founded on the discretion of the court, as that the action is brought for the benefit of, or as trustee for, the sheriff's officer. And in a late case a plea that no affidavit of debt was filed in the action against the principal was held bad upon demurrer. It should be observed that the statute of Hen. 6 only applies to securities given to the sheriff or other officer, and therefore bonds given to the plaintiff in a form different from that presented by the statute are valid. The bail are liable to the plaintiff's whole debt, without regard to the sum sworn to, and costs, to the full extent of the penalty of the bond. And it seems that where bail are let in upon terms to try the cause, the money levied to abide the event, and the bail bond to stand as security, the hail are not liable beyond the penalty, though the debt and costs succeeded after the trial. Each of the bail is liable for his own costs, as well as to the costs in the first action. After the bond is forfeited, the giving time to the principal will not discharge the bail, but if the plaintiff take a cognivant from the defendant without the knowledge of the bail, he cannot afterwards proceed upon the bail bond. Also where a cognivant is taken with the consent of the bail, and the debt is not paid, the plaintiff must give the bail notice that the cognivant is unsatisfied before he can commence proceedings against them. And the court, under 4 An. c. 16, s. 20, exercise a discretionary power with respect to relieving the bail. Section 2 of Replevin Bonds. The Statute Westminster 2, 13 Edward 1, c. 2, s. 3, provides, that the sheriff or bailiffs from thenceforth shall not only receive the plaintiff's pledges for the pursuing of the suit, before they make deliverance of the distress, but also for the return of the beasts, if return be awarded. And if any take pledges otherwise, he shall answer for the price of the beasts, and the lord that distraineth shall have his recovery by writ, that he shall restore unto him so many beasts or cattle, and if the bailiff be not able to restore, his superior shall restore. And the 1 and 2 P. and MC 12, S. 3, enacts, that every sheriff shall, at his first county court day, on within 2 months next after he has received his patent of office, depute, appoint, and proclaim, in the shire or town within his bailiwick, 4 deputies at the least, dwelling not above 12 miles one distant from another, which said deputies so appointed and proclaimed, shall have authority in the sheriff's name to make replevies and deliverance of distresses in such manner and form as the sheriff may and ought to do. Under the Statute of Westminster, the sheriff might, according to his discretion, have taken a bond either from the plaintiff, or from one or more sureties. The practice under that statute has however been, in some measure, superseded by the provisions of the 11 Go. 2, c. 19, s. 23, which enacts, that all sheriffs and other officers, having authority to grant replevins, may and shall, in every replevin of a distress for rent, take, in their own names, from the plaintiff and 2 responsible persons as sureties, a bond in double the value of the goods distrained, such value to be ascertained by the oath of one or more credible witnesses, and conditioned for prosecuting the suit with effect and without delay, and for duly returning the goods and chattels distrained in case a return shall be awarded, before any deliverance be made of the distress, and that such sheriff, or other officer as aforesaid, taking any such bond, shall, at the request and costs of the avowant, or person making cognizance, assign such bond to the avowant or person aforesaid, by endorsing the same, and attesting it under his hand and seal by two or more credible witnesses, and if the bond so taken and assigned be forfeited, the avowant, or person making cognizance, may bring an action and recover thereupon in his own name, and the court where such action shall be brought may, by a rule of the same court, give relief to the parties upon such bond as may be agreeable to justice and reason, and such rule shall have the nature and effect of a defeasance to such bond. Though by the language of this statute it is imperative on the sheriff to take a bond, the court will not grant an attachment against him in case of neglecting so to do, nor will they order him to pay the costs recovered by the defendant in repline, but the proper remedy is to proceed against him by an action on the case. It is not necessarily incumbent on the sheriff to inquire narrowly into the circumstances and responsibility of the persons taken as sureties. It is sufficient if they are apparently, though not actually so, but if it appear that the sheriff had notice of their insufficiency, or neglected the means of information within his power, and did not act under the circumstances, and considering the information he received with a reasonable degree of caution, he will be liable, if either of the sureties be insufficient. The general reputation as to want of credit of the sureties in the neighborhood is evidence against him. It seems that where the sureties reside out of the bailiwick of the sheriff by whom the bond is taken, it is necessary to search the sheriff's office where they do reside, to ascertain whether any process has been sued out against them before the bond is executed. The sheriff is not bound to pursue strictly the terms 11 Go. 2. C. 19, S. 23. If the bond be conditioned to prosecute with effect, it will be good, although it do not require that the suit shall be prosecuted without delay, and although it contains an undertaking to indemnify the sheriff. So if the bond be executed by one surety only, it will be available by the sheriff against such surety, for the 11 Go. 2, C. 19, has not avoided the power which the sheriff formerly possessed under the Statute of Westminster. But where the person making cognizance sued the sheriff upon a bond with one surety only, for taking insufficient pledges, and recovered damages and costs, and the sheriff afterwards sued the surety upon the bond for not having returned the goods, it was held the sheriff was not entitled to recover the costs of the action against him as such sheriff, and that as the surety was deprived of calling on his co surety for contribution, he was only liable to a moiety of the damages awarded by the jury in an action against the sheriff. If the plaintiff neglect to levy his plaint at the next county court, or if he make default in any of the subsequent proceedings, or do not prosecute the suit with effect, the defendant may take an assignment of the bond, for the conditions of the bond are distinct and independent of each other, and a breach of any one of them will occasion a forfeiture. The term prosecuting a suit with effect means with success, and extends to one continued prosecution from the commencement until the termination of the suit, whether in the county court or the court above. Thus, where to debt on bond the defendant pleaded that he had prosecuted the suit with effect in the county court, but that a writ of error had been brought in the court above, where the judgment was reversed, and the plaintiff replied that the judgment in the court above also was that the plaint in the court below should abate, and that there should be a return irrepleviable. Upon demurrer to this replication, the court held that the words to prosecute the suit with effect in the court below, were not confined to the prosecution in that court only, but extended also to the prosecution of the writ of error, as that was part of the suit commenced below. So where the plaint is removed by far, low, into a superior court, the condition of the bond is not satisfied by having prosecuted the suit with effect in the county court, but that the plaintiff must also follow it into the court above. But if the plaintiff's neglect to prosecute the suit has been occasioned by the act of the defendant, as by his not appearing to the summons, or if the proceedings have been stayed by injunction, and during that period the plaintiff dies, the defendant will not be entitled to an assignment of the bond. The bond may also become forfeited by not prosecuting the suit without delay. Thus, where the plaint was levied in the county court, and 2 years were allowed to elapse without any further steps being taken, it was held that the obligee might recover, although judgment of non-pros was never signed in the county court. And where the plaintiff in Riplevin is guilty of a breach of the condition, by not prosecuting his suit without delay, it need not appear that the suit is determined. But where the delay has been occasioned by the neglect of the sheriff to summon the defendant in Riplevine, according to the direction of the Far. Lo, this will not be such a breach of the condition as to make the plaintiff responsible. Upon the neglect of the plaintiff to comply with the to whom as conditions of the bond, the same may be assigned signed, either to the avowant, or to the person making cognizance, where there is no avowant, or to both the avowant and the person making cognizance, who may sue jointly upon it. Where an assignment was not signed by the sheriff, but by a person accustomed to act in the sheriff's office, in the name of the sheriff, and under the seal of the office, it was held sufficient. The action may be brought in the superior court, though the Riplevin has not been removed out of the court below, but if the cause was removed by Far. Lo, the action on the bond must be brought in the same court in which the Far. Lo was returnable. If the action be brought before the forfeiture of the bond, the court will not set aside the proceedings, but will leave the defendant to plead that fact in bar. It was formerly considered doubtful whether a bond which did not in every respect conform to the provisions of 11 Geo. 2, could be assigned, but it seems to have been settled by a late decision, that if the bond be conditioned to prosecute the suit with effect, the assignee in sue upon it, though it do not in other respects follow the terms of the act. The declaration concisely states the proceedings in Riplevine, and the failure in fulfilling the condition of the bond. If the distress were made by the plaintiff as bailiff of another, it is usually so stated, but in a declaration by 2 persons, it is not necessary to state that the one distrained as bailiff, nor need the declaration set out the goods distrained, and if it state the bond was conditioned for making a return of the goods in the condition mentioned, and thereupon the sheriff replied the same, it sufficiently appears the bond was conditioned for a return of the goods distrained. The condition should be correctly stated, but a misdescription in the name of the suitors of the county court is immaterial, and it is no variance to state a removal of the suit out of the court of a person then sheriff, when in fact he was not sheriff. The declaration is not double, although both parts of the condition are negatived, and if a sufficient breach appear, the plaintiff will be entitled to recover, although the breach is not formally as signed. And in an action on a Riplevin bond, taken by the mayor of a city, it is no ground of special demurrer that the declaration does not show a custom for the mayor to grant Riplevines, or that the plaint was made in court. As the plea of non est factum only puts in issue the execution of the bond, all matters of defense must be pleaded specially. The defendant may plead fraud in the judgment in the Riplevin suit, or a payment of rent due at the time of the distress, and costs, or that the sheriff's deputy had not received his appointment at the time he granted the Riplevine. If the defendant plead that he did appear at the next county court, and prosecute his suit with effect, and which suit was still depending and undetermined, it is not sufficient to reply that the defendant did not prosecute his suit, but wholly abandoned the same, and that the suit is not still depending, but it must be also shown how it is determined and ceased to depend. The sureties in a Riplevin bond are liable for double costs, and the value of the goods distrained, if the rent amount to so much, but if the rent due be less than the value of the goods, their liability is limited to the amount of the rent. A distinction was formerly drawn between the case of a surety to a bail, and a Riplevin bond, and it was considered that an agreement with or giving time to the principal in bonds of the latter description would not discharge the sureties, but it would seem that the courts are now inclined to act upon equitable principles, and that the authorities in favor of the distinction cannot be supported. Where the plaintiff and defendant agreed, without the knowledge or consent of the sureties, that all matters in difference should be referred to an arbitrator, and that the Riplevin bond should stand as a security for such sum as should by him be found to be due, it was held that the sureties were discharged. But where the defendant in Riplevine, previously to executing his writ or no habendo, has again distrained the same goods for rent subsequently due, he does not thereby waive his remedy against the sureties on the bond, nor is he by electing to proceed under the provisions of 17 Car. 2, c. 7, s. 2, and taking judgment for the arrears of rent and costs, confined to his execution upon that judgment or prevented from afterwards proceeding against the sureties, and that fact will be no bar to an action on the bond for not prosecuting the suit with effect, without it appears that the sum recovered had been levied and paid to the avowant before the commencement of the action on the bond. Section 3 of Administration Bonds. The 22 and 23 Car. 2, c. 10, requires the ordinary to take from the person to whom administration is granted a bond with 2 or more sureties, and also prescribes the form of the condition, which is in substance as follows. First, that the administrator make a true and perfect inventory of the goods of the intestate, and exhibit the same in the registry of the prerogative court. Second, that he well and truly administer, according to law, the same, and all other goods that shall come to his hands or possession, or to the hands or possession of any other person for him. Third, that he make a true and just account of his said administration. Fourth, that he deliver and pay over the rest and residue of the goods that shall be found remaining upon his account unto such persons respectively as the judge of the court shall, by decree or sentence, pursuant to the above statute, limit and appoint. Fifth, that he deliver the letters of administration into court, in case any will of the deceased shall appear. The non-delivery by the administrator of a true and perfect inventory, or that he has not made a true and just account, may be well assigned as a breach of the condition of the bond. But the questions that have arisen upon these bonds are principally confined to the clause requiring the administrator well and truly to administer according to law, and in an early case, it was held, that the non-payment of a debt to a creditor could not be assigned as a breach of this part of the condition. The law on this subject has been fully examined and settled by late authorities, and it is clearly established that the neglect of an administrator to distribute the surplus of the intestate's effects before a decree of the ecclesiastical court has directed him so to do, cannot be assigned as a breach of the condition of the bond. To debt on bond, with condition as above, the defendant, after craving oyer of the bond and condition, pleaded, that the administrator had performed the 3 first branches of the condition, and that as to the 4th branch, that the judge of the court had not, by decree or sentence, limited or appointed the administrator to pay the residue of the goods, or any part thereof, which were found remaining upon the said accounts of the administrator to any person whatever, but that, on the contrary, the administrator was cited to appear before the commissary of the court to exhibit an inventory, render an account of his administration, and see portions allotted, and a distribution made of the goods, that the administrator did appear in consequence of such citation, and such proceedings were had in the court, that he was duly dismissed from all further observance of justice in the cause. To this plea the plaintiff by his replication alleged and assigned, as a breach of the condition, that certain persons particularly named were the only next of kin of the intestate, that the administrator paid all her debts, that goods of great value, and more than sufficient to pay all debts and charges of the administration, came to the hands of the administrator, which ought, according to the condition, to have been duly administered by him according to law, that is to say, in manner following, to wit, by paying certain sums, specified in the replication, to the persons before mentioned as the next of kin, whereof the administrator had notice, that a reasonable time for doing this had elapsed, yet the administrator had not administered the goods according to law, or paid or delivered the goods, or any part thereof, to the persons before named, or either of them, but neglected and refused so to do, contrary to the effect of the condition, whereby the persons before named have lost the use and profit of their proportions of the goods. The defendant having rejoined, that the judge of the court had not by decree or sentence limited and appointed the administrator to deliver or pay the goods to the persons named, or any other person, the plaintiff demurred generally, and the point for argument was, whether the refusal of the administrator to distribute the surplus or residue of the effects of the intestate among the next of kin according to the statute of distributions, without the previous decree or sentence of the court, was a breach of the condition of the bond. Lord Tenterden, C. J. after commenting upon the statute and the terms of the condition, observed, that the words well and truly administer the goods according to law, could not be understood of an administration comprising a distribution among the next of kin, that where an administrator intends to act faithfully, and the claims of the next of kin can be, as in general they may be, ascertained without difficulty, he will not put them to the expense and delay of calling for his account, and obtaining the sentence of a court, and therefore it is well said that it is his duty to make a distribution, although it cannot be said that forfeiture of the bond is incurred if this be not done. But where an administrator converts the effects of the intestate to his own use, and afterwards becomes bankrupt, and the effects are thereby wholly lost, such conduct will be a direct breach of that part of the condition requiring him well and truly to administer the goods of the intestate, and the surety in the bond will be liable for the full amount of the money so misapplied to debt against the defendant as surety on a joint and several administration bond. He pleaded non est factum, and the plaintiff assigned breaches on the roll negativing the several branches of the condition. On the trial it appeared that the administrator had possessed himself of the intestate's effects to a considerable amount, one part of which he applied in discharge of the debts and funeral expenses of the intestate, another part in payment of one of the next of kin, but the residue he converted to his own use, and afterwards becoming bankrupt it was entirely lost to the estate of the intestate. A verdict was found for the plaintiff, subject to the opinion of the court as to whether the conduct of the administrator amounted to a breach of that part of the condition which required him well and truly to administer the effects of the intestate, and the court were of opinion that, looking at the language of the bond, nothing could be a more direct infringement of the terms of the condition than the application by the administrator of the effects of the intestate to his own use, and the converting them to his own purposes, so that they were entirely lost to the estate of the intestate. If the bond be forfeited, the parties desirous of suing upon it at common law must pray the ecclesiastical court to pronounce it forfeited, in order to its being put in suit. Section 4 of Bastardy Bonds. The Poor Law Amendment Act has repealed the statutory provisions under which bastardy bonds were formerly given. Before that act came into operation, magistrates were empowered to commit to prison any person charged with being the father of a bastard child, until he should give security to indemnify the parish. Now, however, when any bastard child has become actually chargeable to the parish, the overseers or guardians may, after diligent inquiry as to the father of the child, apply to the quarter sessions for an order on the putative father to reimburse the parish, and if the court, after hearing evidence thereon, shall be satisfied that the person charged is really and in truth the father of the child, it shall make such order as shall appear reasonable under the circumstances of the case. The 70th section of 4 and 5 William 4, c. 76, enacts, that every security given, or recognizance entered into, by any person or persons, or his or her surety, before the likely to be passing of that act, to indemnify any parish or place as to any child or children likely to be born a bastard or bastards, whereof any single woman shall be pregnant at the time of the passing of that act, or to abide and perform such order or orders as might have been made touching such child or children, pursuant to an act made and passed in the 18th year of the reign of her late Majesty Queen Elizabeth, concerning bastards begotten and born out of lawful matrimony, shall be and the same are thereby declared null and void, and every person who shall, at the time of the passing of that act, be in custody upon the commitment of any justice or justices for not having given such security, or entered into such a recognizance, shall be discharged, upon the application of such person, by any one of the visiting justices of the jail in which such person shall be in custody under any such commitment. As, however, the 4 and 5 William 4, c. 76, only applies to future-born bastards, and does not affect bonds already entered into for indemnifying parishes against the expense of children born before the passing of that act, it is considered expedient briefly to notice the law respecting such bonds. Where the bond was given under compulsion of the statute, its provisions must have been strictly complied with, and therefore the condition could only be to indemnify the parish. But if a party voluntarily gave a bond to the parish officers for the purpose of providing for the maintenance of his illegitimate offspring, such bond was valid, even though it went beyond an indemnity to the parish. The right of suing upon the bond vested in the overseers for the time being, and as they were under a legal obligation to maintain illegitimate children, it was not necessary that there should have been an order made for that purpose, to enable them to recover on the bond. They could only recover the sum actually expended in the maintenance of the child. And in no case was the obligor liable beyond the amount of the penalty. It has been frequently mooted, though never yet determined, whether or no a putative father has a right to the custody of his illegitimate child, and can plead his willingness to maintain it, in discharge of an action on the bond. In a late case such a plea was put upon the record, but the court held that as the bond was not in terms conditioned to indemnify the parish, but was simply for the performance of one particular act, namely, the payment of a weekly sum on account of costs, charges, and expenses, it was not necessary to enter into the question as to how far the offer of the father to maintain the child would relieve him from his liability. This point is still of some importance, since, if such a defense could be pleaded to a bond, it is equally applicable to the enforcement of an order made by the quarter sessions, in pursuance of the provisions of the recent Act. Section 5 of Annuity Bonds, by the 53 Go. 3, c. 141, which repealed a 17 Go. 3, c. 26, except so far as regards annuities granted before the passing of the first mentioned Act. It is required that within 30 days after the execution of every bond, and c. whereby any annuity or charge is granted for one or more life or lives, or for any term of years or greater estate determinable on one or more life or lives, a memorial of the date of every such bond, of the names of all the parties, and of all the witnesses thereto, and of the person or persons for whose life or lives such annuity or charge shall be granted, and of the person or persons by whom the same is to be beneficially received, the pecuniary consideration or considerations for granting the same, and the annual sum or sums to be paid, shall be enrolled in the High Court of Chancery. Otherwise every such bond shall be null and void to all intents and purposes. By the 4th section it is enacted, that where the persons to whom the annuity is granted shall not be entitled beneficially thereto, the names of the persons who are so entitled shall be described in the enrollment, otherwise the bond shall be null and void. The 10th section provides that the Act shall not extend, first, to any annuity or charge secured upon freehold lands of equal or greater value than the annuity, over and above any other annuity charged or secured for such lands. Second, to any voluntary annuity or charge granted without regard to pecuniary consideration, or money's worth. Third, to any annuity granted by any body corporate, or under any authority or trust created by Act of Parliament. To constitute an annuity within the meaning of the above Act, the principal must be irrecoverably gone. Therefore a bond conditioned for the payment of a sum of money to the executors of the obligee, and interest in the meantime to him, is not an annuity bond, and does not require to be enrolled. To bring an annuity within the first part of the 10th section, the other annuity must be directly and specifically charged on the land, and not merely secured in a manner that may by possibility affect it, as by judgment entered up on a warrant of attorney. This statute applies only to annuities for which a pecuniary consideration has been given. Thus where the condition of the bond recited that the plaintiff was entitled to an interest in certain mines of coals for life, and that by indentures of even date with the bond the annuitant assigned such interest to the defendants, who in consideration thereof had agreed to pay her a certain annuity for life, and the bond was conditioned for the payment of that annuity, the defendants, having pleaded that no memorial was enrolled, the court, in giving judgment, observed, that the Act did not extend to cases of fair and bona fide sales of landed property, whether freehold, for life, or leasehold, where the consideration in part or in whole might be an annuity to be paid to the vendor. So where by the condition of the bond it appeared that 1,000 litres was to be given by a father on the marriage of his daughter, to trustees upon trust to pay the interest to the husband for life, and the father died without having paid the principal to trustees, and his affairs being embarrassed, and it being uncertain whether there would be sufficient to pay his debts, the husband agreed to accept, in lieu of the 10,000 litres, 6,000 litres. and an annuity of 125 litres, payable during his life. It was held that though the preamble of the 53 Go. 3, c. 14, was not so extensive in terms as the 17 Go. 3, c. 26, yet there was sufficient in other parts of the first mentioned Act to show that the legislature had in view the same object, viz. the preventing the sale of life annuities, and that to bring a case within the 53 Go. 3, c. 141. There must be an actual sale of an annuity for money, bills, or goods. Again, where the condition of the bond recited, that the defendant having been indebted to the late husband of the plaintiff in a large sum of money on a balance of accounts between them, and it was agreed that, in lieu of payment of part of such balance, the defendant should by his bond secure to the plaintiff, after the decease of her husband, during the joint lives of the plaintiff and defendant, an annuity which was stated in the husband's will to be settled upon the plaintiff, that the husband was dead, and that the annuity had been paid up to a certain period. The condition therefore was, that the defendant should, during the said joint lives, pay the said annuity to the plaintiff, or her assigns, on a certain day in every year. It was held that this bond did not require enrolment under the 17 Go. 3, c. 26. Frequent questions arose as to what was a sufficient compliance with that act, in the statement of the nature and extent of the securities, and the description of the consideration. The 53 Go. 3, c. 141, in some measure obviated the previous uncertainty, by providing a concise tabular form of the statement of the memorial. From this form, however, it became questionable whether or no it was necessary to state the description and place of residence of the witnesses to the bond, as the enacting clause of the statute did not require it. The Court of King's Bench were of opinion that it was the intention of the legislature that they should be stated, and where a witness was merely described as the clerk of an attorney whose abode was mentioned, they considered the description as insufficient, as the clerk did not reside there, but merely attended at the office. Considerable doubt having been entertained as to whether the right construction had been put upon this act, the question was set at rest by 3 Go. 4, c. 92, which enacted that no further or other description of the subscribing witness to any bond, whereby any annuity or rent charge is granted, is required in the memorial. Besides the names of all such witnesses. The second section declares that every bond granting any annuity, of which a memorial shall have been enrolled, shall be valid, notwithstanding the omission to enroll any other bond for any such annuity. The 7 Go. 4, c. 75, further provides that the names of the witnesses may be stated in the memorial as they appear in the bond. Where the defendant relies upon the want of enrollment, and the consideration does not appear by the bond itself, it is not enough to plead generally that no memorial of it was enrolled, but it must likewise be shown that the consideration was pecuniary. And if it be pleaded that the memorial is insufficient, it is necessary to show in what way it is defective, or that no other memorial has been enrolled. And where to an action of debt on bond the defendant pleaded no such memorial as the statute requires, to which the plaintiff replied that there was a memorial, which contained the names of the parties, and the consideration for which the annuity was granted, the defendant rejoined that the consideration was untruly alleged in the memorial to have been paid to both obligors, for that one of them did not receive any part of it. The rejoinder was held bad, first, because it was a departure from the plea, secondly, because the fact alleged did not contradict the replication, for the consideration might have been paid to the other obligor on account of himself and the co-obligor, or to a stranger for both of them. A bond conditioned for the payment of an annuity to the wife of the obligor, unless she should at any time molest him on account of her debts, or for living apart from her, is not discharged by a subsequent cohabitation, unless there appears a clear intention that it should be avoided in the event of a reconciliation. Section 6 of Arbitration Bonds. Where matters in difference are referred to arbitration, the submission is frequently made by cross bonds. In such case the obligatory part is in the form of a common money bond, with condition to abide the event of the award. The 9 and 10 will. 3, c. 15, s. I, enables the parties to insert in the condition a stipulation that their submission shall be made a rule of a court of record. The condition should also contain such powers, provisos, and stipulations as are usually inserted when the reference is by agreement or indenture. These will of course vary according to the nature of each particular case, but as a minute inquiry into this subject would be foreign to a treatise of this description, the reader is referred, for information on this point, to the several works on arbitration. It should, however, be observed, that in every case the condition ought to contain a stipulation against revocation by death, marriage, or bankruptcy. Where there were 3 obligors, and one died before award made, it was held that the arbitrator could not award payment to the survivors and the executors of the deceased, though it seems the award would have been good if made in favor of the survivors only. But where the deed of submission provided that the arbitrator's authority should not expire through the death of either party, and the arbitrator by his award directed the executors of one of the parties, who died before award made, to pay a certain sum to the other, and the party in whose favor the award was made, sued the surety on the bond, in which the clause as to the death was not inserted, and the surety pleaded performance according to the covenants contained in the deed of submission, it was held that the authority of the arbitrator was not determined by the death. An executor should stipulate against being personally liable, otherwise he admits assets by entering into the bond. Impartial or improper conduct in an arbitrator in making his award, cannot be pleaded in bar to an action on the bond, but is only matter for application to the equitable jurisdiction of the court. Section 7. Of bonds to replace stock. Bonds to replace a loan of stock on a certain day, and in the meantime to pay the dividends, are not of themselves illegal, since there is a possibility of a depreciation in the value of the stock. But if the agreement be such that the lender is secure from loss, and receives, by way of dividend, more than the legal rate of interest, the contract may be avoided on the ground of usury. Thus, where it appeared that the obligor was indebted to the obligee in £486, 4s. 6d, which the former being unable to pay, it was agreed that the latter should forbear an action which he had commenced until a certain day, in consideration of the obligor giving to him a bond to transfer on that day so much stock as £486, 4s. 6d, would purchase at the then present day's price, which would amount to £908, 16s. 7d. Together with such interest as the same would have produced as such stock in the meantime. Thedgery having found the transaction fair, and not a mere colour for usury, the court agreed the bond was legal, for the amount of the sum to be paid by the obligor depended on a contingency, and if the stocks had greatly fallen in the meantime, the obligee might have received less than his principal and interest. So where the condition was, that the obligors should, on a certain day, transfer to the obligee £400 stock, or pay to him the value thereof, and it appeared that the value of the stock, when the agreement was made, was £240, but at the time of the action brought £225 only, this bond was adjudged to be legal. Also it has been held, that a bond, with condition for the retransfer of stock on a certain day, and in default thereof for payment of the money produced by the sale, and in the meantime also for payment of the dividends, is not usurious, even though the dividends exceed the legal rate of interest. But where there was a contract for the repayment of a debt, or at the option of the creditor, to transfer so much stock as the amount of the debt would have produced on the day it was payable, the transaction was considered usurious, for the principal and interest being secured, the creditor might take the opportunity of a rise in the stocks to make his election, and thus he would be sure to be a gainer, while he could not possibly sustain any loss. And in every case where the exact value of the stock to be sold or replaced has been previously estimated by the parties, so that nothing depends upon contingency, the contract will be usurious if more than the legal rate of interest is reserved. In an action for a breach of the condition to replace stock, the true measure of damages appears to be its value at the day appointed for the transfer, if the stock have fallen in value before the trial, but if the stock have risen in the meantime, the highest value as it stood at the time of trial. The obligee cannot, however, recover special damage for a profit which he might have made of it, if sooner replaced, unless he has demanded payment for that express purpose. and has given the obligor notice that he should call on him to pay the difference. Section 8 of Bottomry and Respondentia Bonds. Bottomry is an agreement by which the owner or master of a ship or vessel, in consideration of a sum of money advanced to enable him to carry on a voyage, undertakes to repay the same with a stipulated interest, if the voyage prove successful, and in the meantime pledges himself, the ship, and tackle, for the due performance of the agreement, and if the ship and tackle arrive in safety, they are liable, as well as the person of the borrower. But if the ship be lost, the lender also loses his whole money. It should be observed that it is the essence of bottomry that the lender should take upon himself the risk and perils of the voyage, and therefore where the master of a ship in a foreign port, by an instrument under seal, bound himself, the ship, freight and cargo, for the repayment of money advanced for her repairs, with £12 per cent. Bottomry premium, in 8 days after his arrival in London, and the vessel, freight and cargo were to be liable, whether she arrived there or not. This was held to be misdescribed as a bottomry contract. It is not however necessary that the bond should expressly declare that the lender takes upon himself the risk of the voyage. Though it is usually done, it is sufficient if that fact can be collected from the general terms of the instrument. Thus, where a bond executed in a foreign port by the master of a ship, after reciting that his vessel bound to London had received considerable damage, and that he had borrowed a sum of money to defray the expenses of repairing her, proceeded thus: I bind myself, my ship, her apparel, tackle, and sea, as well as her freight and cargo, to pay the above sum, with £12 per cent. Bottomry premium, and I further bind myself and the said ship, her freight and cargo, to the payment of that sum, with all charges thereon, in 8 days after my arrival at the port of London, and I do hereby make liable the said vessel, her freight and cargo, whether she do or do not arrive at the port of London, in preference to all other debts or claims, declaring that this pledge or bottomry has now and must have preference to all other claims and charges, until such principal sum, with £12 per cent. Bottomry premium, and all charges, are duly paid. It was held upon error from the common pleas, that this was an instrument of bottomry, for an intention sufficiently appeared from the whole of it, that the lender should take upon himself the peril of the voyage, and that the words my arrival, must be understood to mean my ship's arrival, and that the words, I make liable the said vessel, her freight and cargo, whether she do or do not arrive at London, were intended only to give the lenders a claim on the ship in preference to other claims, in case of the ship's arrival at some other than the destined port, and not to provide for the event of a loss of the ship, where the loan is not made upon the ship or vessel, but upon the goods and merchandise which must be necessarily sold or exchanged in the course of the voyage. There the borrower only is personally bound, and is said to take up money at respondentia. The condition of a bond, after reciting that money was lent upon the goods laden and to be laden on board a certain ship on her voyage out and home, was, that if the ship should proceed on her voyage and return within 36 months, the dangers of the seas excepted, and if the borrower, within 30 days after her arrival, should pay to the lender the sum agreed on, or if in the voyage and within the 36 months the ship should be lost by fire, enemies, or other casualties, the borrower should, within 6 months after such loss, pay to the lender a proportionable average on all the goods carried out and acquired during the voyage which should be saved. Then the obligation to be void. This was held to be no more than a personal obligation from the borrower to the lender, and did not give the latter any specific pledge or lien on the home cargo, or the proceeds thereof. However much the interest reserved by these bonds exceeds the rate allowed by law, the contract will not be considered usurious, since the lender risks both principal and interest, but should the hazard go only to the interest or premium, and not to the principal also, the bond will be illegal. Nothing short of a total destruction of the ship will discharge the borrower of money upon a bottomry bond, if the ship be captured and detained for a short time, or if it exist in specie, though in such a state as might have made it prudent for the owner to dispose of it, the obligee may recover on the bond. Section 9 of Postobit Bonds. Postobit bonds are of two kinds. First, when the payment of a greater sum than that advanced depends on a contingency. Second, when the payment of the greater sum is certain, but the time of payment is contingent. If these bonds are given on a bona fide contingency, they cannot be impeached on the ground of usury. They are, however, considered as securities of a questionable nature, and therefore the courts of law have refused to allow judgment to be entered up on a warrant of attorney, given with a post-obit bond, without a rule to show cause. But if the consideration be inadequate, a court of equity will in general grant relief, and especially in the case of expectant heirs, but the obligor will be required to restore to the obligee the money paid, together with interest. And as the validity of these bonds entirely depends upon the risk of the money lent, if the obligee be indemnified by an insurance on the life on which contingency depends, and the obligor bear any part of that expense, a court of equity will order the bond to be cancelled. Section 10 of Indemnity Bonds. Where the obligor of an indemnity bond undertakes generally to save harmless from the consequences of a particular act, the bond is forfeited upon the obligee being damnified, and it is not necessary that notice should be given to the obligor, whether the indemnity be against the acts of the obligee or a third person. A condition to save harmless from all actions, legal proceedings, and costs, which might arise from the obligee delivering to the obligor a bill of exchange, part of the proceeds of which a third person was entitled to, is broken by the obligee paying to such third person his share of the proceeds upon his demanding the same, without bringing any action. So an obligation to save harmless from all suits, quarrels, and demands, concerning a bond in which the party indemnified was bound as surety, is forfeited by such surety paying the money due on the bond without demand. For where there is a legal obligation to do the act against the consequences of which the indemnity is given, the liability of the obligor will attach, though that act has been done by the obligee without compulsion. An undertaking to indemnify against a certain engagement will extend to any expense which falls upon the obligee by reason of that engagement. And the obligor of a bond conditioned to indemnify the obligee against his wife's debts, is liable for the costs and expenses incurred by the obligee, in an action against him for goods supplied to the wife. A condition to indemnify against all mortgages, judgments, and executions, had or obtained, or thereafter to be had or obtained, by a particular person, will extend to the wrongful entry of such person, but a condition to indemnify against the acts of all persons is confined to a lawful entry or eviction. Where the indemnity is given as a security for money to be advanced, it frequently becomes questionable whether the guarantee is continuing. This will, of course, depend upon the language of the instrument, and the intent of the parties to be collected therefrom. A condition for payment of all sums not exceeding 3,000 litres, which should at any time thereafter be advanced by the obligees to a third person, has been held not a continuing guarantee, but only a guarantee for advances once made to the extent of 3,000 litres. But where the condition was to indemnify the obligees for such sums as they in their banking business should for 10 years advance or pay on account of bills of exchange which a third person should, from time to time, draw on them and make payable at their house, and also all allowances for advancing and paying such bills and accommodations, not exceeding in the whole 5,000 litres. It was held to guarantee running accounts, and not satisfied by the part payment of 5,000 litres to an action on an indemnity bond, the proper plea is non damnificatus, and the plaintiff replies, showing how he was damnified. But if the defendant rely on any matter in excuse of performance, it must be specially pleaded. So if the plaintiff be damnified in his own wrong, it should be so stated, for if the defendant merely plead non damnificatus, he cannot afterwards rejoin that the plaintiffs were damnified in their own wrong, as such rejoinder would be a departure. Also, if the condition be to discharge or acquit the plaintiff from a certain bond, or other thing, the plea of non damnificatus is improper, though it is otherwise if the condition be to discharge or acquit from any damage by reason of such bond or other thing, for that is in effect a condition to indemnify. Also, if the condition be for payment of money at a certain day, non damnificatus cannot be pleaded, though it appear that the bond was given by way of indemnity,